and welcome to company law. We are continuing with the discussion of capacity of companies, and then we look at the objects of companies, constitution of a company, and the name of a company. Assuming that you have revised what we discussed the last time, as far as the theory of incorporation is concerned, and also lifting or piercing the corporate veil is concerned. Let me share the screen. Just a minute. Let's see. The screen is supposed to be open. After the screen is here. Okay, so turn with me to section 18 of your law. You notice that part C. Who is going to be the class reader? If you want to be the reader, raise up your hand so that I will meet you and you can be reading for us. So if you look at part C, is headed capacity of companies. Now, just a little bit of a background before we move on. Capacity, okay, thank you, yeah, so capacity, I'm making you a co-host so you can mute and unmute yourself. If I need to read, then you read. You can unmute yourself. Yeah. Okay, so just a little bit of a background before we look at the law itself. Capacity is a big deal for the incorporated company, and in the past, there was something we call the doctrine of ultra vires. And ultra vires, as you've encountered it in your maybe constitutional law, administrative law, and legal system, simply means that you have exceeded your power, you've exceeded your mandate. Now, for the company, what that meant. Now, for the company, what ultra vires meant was that where the company had, for example, engaged in a transaction which was seen to be outside the mandate or the capacity of the company, that transaction was null and void and could not be binding on the company. So if you look at the old cases like the Ashbury Railway versus Ritchie, let me put it here for you. It's just for academic purpose because it's really not important these days. Ashbury Railway against Ritchie. We'll look at the chart. Now, if we look at a case like that, for example, the doctrine of ultra vires was actually asserted, and it was like a big deal because the position of the courts was that if a transaction the company had engaged in was outside the objects, outside the nature of business for which the company had been incorporated, that transaction was no longer binding. Yeah, so that is the Ashbury Railway against Ritchie. Of course, that was quite problematic. And for that matter, if you look at Gowers Commission, which made recommendation for the adoption of the old companies legislation, that is the Companies Code 1963 at 179, they were concerned about not frustrating genuine intentions of third parties dealing with the company, so that person who genuinely dealt with the company and all that should not end up getting frustrated just because the companies engage in a transaction not permitted by its object clause and all that. And let me also say that if you go back to English company law, where we have what you call the dual constitutional documents, the memorandum of association and articles of association. The memorandum of association, for example, had what you call the object clause, like a statement of what the company was set up to do. And that was, if you like, the guiding compass for making a determination as whether a particular transaction which the company had engaged in was a transaction which is in accordance with its stated objects or the nature of business for which the company had been established. Yeah, so that was it. So later on, Gowers, they made some modification to the common law doctrine of Travaris and said that if the transaction which I'll be engaging also ordinary Travaris would not really operate automatically as being void and so on, and some protection can be given to like the third party. Now, I must say that that modification has also been has continued or has been reenacted in the Companies Act 2019, Act 992, as per section 18, section 18 and 19. The only difference is that unlike the old system, if you look at the old law, for example, the predecessor to section 18 and 19, they used the heading was what we call like you see like Travaris expressly there. Immediately after the powers of capacity of company, we have like the Travaris. But now, if you go through all the provision and the capacity of companies, you notice that Travaris is not expressly provided for. So the point will be made that by some commentators that Travaris doctrine has been abolished from our new companies code. Well, they may not be wrong in saying that, except that it's too sweeping a statement. The proper understanding of the new law is that, unlike the past, in which we highlight the general operation of, if you like, Travaris doctrine as part of a company law, what we have done now is that unless a company decides to impose upon itself certain stated objects or a clear statement of the nature of business with which the company was registered, in which case the company's activities may be judged according to its own statement of objects. So it's now optional. It's not mandatory for, if you like, a company to have a statement in terms of its objects, in terms of the nature of business that the company may engage in. These are the things I would like us to have at the back of our mind as we discuss the substantive provisions on capacity of companies. So having said that, let us look at section 18 of Companies Act 2019 Act 992. So maybe the reader may take 18 for us. Okay, he's gone. So anyway, that's fine. Yeah, so if you look at 18.1, subject to this act and to any other enactment, a company shall have a full capacity to carry on or undertake any business or activity, do any act or enter into any transaction, and B, full rights, powers, and privileges for the purpose of paragraph A. Now, we've already encountered this when we were discussing the theory of incorporation, that one of the obvious consequences of incorporation is that a company comes into existence and then it acquires a capacity, just like a natural person, to be able to engage in all manner of transactions or activities. So that is exactly what section 18.1 has sought to do for us. But if you look at the of course, the subsection 2 of 18 also makes the point, and I quote that, without limiting subsection 1 and despite provision of any other enactment, a company shall be capable of giving and entering into and being bound by and claiming all rights under a deed or mortgage or other instrument. So it's not just ordinary contractual transactions which the company may engage in. A lawmaker is saying that when it comes to major things like interest in land, transfer of interest in land, or using an interest in land as a security and so on, the company can engage in that just like any other person. But the important thing to note for purposes of the point that I was making not long ago is section 18.3. So section 18.3 reads, and I quote, the registered constitution of a company may contain a provision regarding the capacity, rights, powers, or privileges of the company, if the provision restricts capacity of the company or those rights, powers, and privileges, unquote. In other words, there is nothing wrong for a company on its own to have a constitution that is a registered constitution, and in the constitution, for example, specify that the company can do certain things or cannot do certain things. Now, where that is actually indicated, then certainly things that the company has said per its constitution that it cannot engage in, should the company engage in that, that would be considered ultra vires. So here, you notice that it is not really mandatory for the company to have a statement of objects, for the company to state clearly that we are registered to do X, Y, Z, in which case the ultra vires doctrine will have applied automatically should the company ever engage in transaction outside those X, Y, Z that it says that it's registered to do. On the other hand, where the company goes out of its way and indicates in its constitution that it is supposed to do only X, Y, Z, then should it engage in a transaction which is outside that, the doctrine of ultra vires may apply, mutatis mutandis, that is, with necessary modifications. So let's look at 19, limits of authority of the company, and that is where it makes it more poignant. 19.1, is a reader available? Okay, it's gone. Where the registered constitution of a company sets out the nature or objects of the company. Yeah, Kojo Yabua, I wanted you to continue 19.1. Can read it. Yes, go ahead. Okay, we don't have time, which is not right. Let's proceed. Yeah, so where the registered constitution of the company sets out the nature of business or objects of the company, there is deemed to be a restriction in the registered constitution on the business or activities in which the company may engage, unless the registered constitution expressly provides otherwise. So let us understand 19.1. And 19.1 is introducing the doctrine of ultra-vires within a defined context or in a narrow situation. And what is that? That is to say that where a company has a constitution, a company does not have to adopt its own registered constitution. But where a company adopts a constitution, in which case we say that the company has a registered constitution. And if in the registered constitution, the company, for example, decide to state the nature of business or object, that is the kind of activities that the company may engage in, then in that case, the general rule is that the company has imposed a restriction on itself. And for that matter, it cannot engage in transaction outside the remit, outside the scope of the stated objects or the nature of business. Except where maybe the constitution of the company says that despite the fact that we have specified these activities, there's nothing wrong for the company to go outside it. Otherwise, the position is that insofar as the company has a registered constitution and has gone out of its way to state in the registered constitution that it's supposed to engage in certain specified activities, and the company cannot go outside that. So let us keep that in mind. And that is where, as I said, ultra-vires becomes relevant. So therefore, it is not completely correct for anybody to say that ultra-vires doctrine has been abolished in Ghana's company law. That would be a wrong understanding of the law. The proper understanding is that where a company has adopted a registered constitution, has also made a statement of the object or the nature of business, then ultra-vires doctrine applies within that context. But as I said, the common law doctrine of ultra-vires has been modified. And for that matter, we need to look at subsection 2 of section 19. So if you look at subsection 2, it reads, and I quote, where the registered constitution of a company provides for any restriction on the business or activities in which the company may engage, A, the capacity and powers of the company shall not be affected by that restriction. And B, an act of the company, contract or other obligation entered into by the company and a transfer of property to or by the company shall not be invalid by reason only of the fact that it was done in contravention of that restriction. So as I said, the modification we have to the common law doctrine of ultra-vires here is that a common law where ultra-vires applies, automatically the transaction is void. However, under Ghanaian company law, as we see from section 19.2, we are told that even where you have a registered constitution and you have imposed the statement regarding the nature of business on the company, the fact that the company has, for example, engaged in transaction outside the statement of the objects or the business is not automatically going to render the transaction void, right? The mere fact that you've ultra-vires it is not going to make it void. So that is what 19.2 is telling us. However, if you look at 19.3, it makes a certain concession that subsection 1 shall not affect application of the provision of subsection 5 and section 200, 219, and 275. Now, you will notice that it is possible, or the law makes it possible for certain persons, including members, who are, for example, aggrieved by a company engaging in a transaction which ordinarily looks ultra vires. For example, go to court for the court to grant a remedy, and usually injunction, particularly so where the transaction is still executory. Executory means that it has not fully been carried out, is yet to take place, in which case, if the court is persuaded, the court can grant an order of what? Injunction. So if you look at subsection 4, for example, that despite subsection 1, an act of a company and a conveyance or transfer of property to or by a company is not invalid by reason of the fact that the act, conveyance or transfer was not done or made for the furtherance of any of the authorized businesses, or that company was otherwise exceeding its object or purpose. So 19.4 is trying to protect interests of third parties who, for example, offended in transaction with the company with respect to maybe acquisition of interest in land or whatever, that the fact that the company, for example, engaged in that transaction outside these stated objects or nature of business will not render the transfer or the acquisition of that interest invalid. So here, as again, we see modification of the common law doctrine trying to protect third parties. And this is consistent with what Gower Commission said. If you look at Gower's commentary in the Gower's report, particularly the commentary on the repealed section 25 of the old Act 179. But the good thing is that, and as we have seen in 19.3, that certain persons who are aggrieved by the company engaging in ultra vires transaction under certain circumstances, particularly where the transaction is executed, that is, the transaction has not fully been carried out, they may go to court for remedy. So let's look at 19.5. 19.5. Will anybody read it?
19.5. On the application of a member of the company or the holder. So should I read?
Yes.
Secured by floating charge over all or any of the property of the company or by the trustee for the holder of these debentures. The court may prohibit by injunction the doing of an act or the conveyance or transfer of a property in breach of subsection 1.
Okay, good. So 95 is telling us that where the company, for example, has engaged in a ultra vires transaction, as a general rule, it is not invalid or is not void. However, subsection 5 makes it possible for a member of the company or the debenture holder, right? Especially a debenture holder who has a floating charge, to go to court and tell the court that the ultra vires transaction, which has not yet been carried out by the company, should not be allowed to be completed. And then the court will grant injunction. Now, where the court, for example, should grant injunction under subsection 5, the court is permitted by subsection 6 to have regard to all the circumstances of the case and make certain orders which will ensure fairness and which will be equitable, ensure that the parties to the contracts have been fairly treated, so that you don't defeat the purpose, the spirit of what we saw under subsection 1 and 2, that the mere fact that the transactions of ultra vires shall not render the transaction not void. But at the same time, the law is trying to create a balance, ensure balance, right? Balance in the sense that where in appropriate circumstances, or Tavares transaction is going to hurt interests of members, but it's going to hurt creditors, especially creditors whose security is one of a floating charge, then the court may intervene and prevent that transaction from taking place. But it may also be that so I was making the point that yes, where there's a Tavares transaction and then the court is, for example, persuaded when so approach under section 19.5 and it has granted injunction, the court may make certain equitable orders to ensure fairness, especially so where maybe certain parties have either parted money under the contract, which is going to be injuncted and cannot be carried out fully by reason of the Tavares and all that, then the court will make the necessary orders to ensure fairness, either ordering compensation to be paid or whatever. So that is what 19.6 actually seeks to achieve. Look at that. Now let's look at the 7 before we go. 19.7. The capacity of the company to do an act shall not be affected by the fact that the act is not or will not be in the best interest.
The capacity of the company. Okay.
Yes, go ahead. Yeah, okay. So
the alteration of the subject or the business. Should I read the 7?
Yes, go ahead. Yeah.
Okay, 7:20. Where applicable, a company may change the business for which the company was incorporated to carry on, or in the case of a company not formed for the purpose of carrying on a business, the object of the company by special resolution. 2, within 28 days of the passing of the special resolution under subsection 1, notice of the resolution shall be given in the prescribed form to the holders, debentures secured by a floating charge over any of the properties of the company, and to the trustees for the debenture holders. Should I go on with the 3, please?
No, it's okay. Yeah, so I want you to pay attention to the 20 subsection 1. The opening said where applicable, and I want you to underline that, where applicable. That is to say that the lawmaker does not make it mandatory for all companies to have registered constitution. And also does not make it mandatory for all companies to have a statement of objects or the nature of business with which the company is what? Incorporated. It's not mandatory. And that is why the provision says that where applicable. So where applicable means that where the company has a registered constitution, and then the registered constitution, it has a statement of objects. That is what the company is set out to do, the nature of business. Then Fuente is saying that it is possible for the company to make changes to that statement of what? Object or purpose. And it can be done by passage of a special resolution. So a special resolution, as we discuss members meeting and all that, you notice is one of the resolutions which the company may pass. The company must give notice that it's going to pass a special resolution when it is sending notice for the meeting. And during the meeting, the 75% of those who are eligible to attend the meeting and then they attend the meeting must actually vote in favor of the resolution. So that is what makes a special resolution. So prior notice is given in the notice convening the meeting, and 2, it must secure 75%. That is 75%, just about like the 3/4 of those who are eligible to vote and attending the meeting. So that is that. But if you look at the 22, it says that within 28 days, when the resolution is passed to change the nature of the object, you must notify the debenture holders. And question may arise, why is that necessary? Well, the debenture holders are creditors of the company, okay? They have given credit to the company. But we have two types. We have secured debenture holders who have fixed charge, and then we also have those who have floating charge. For those with fixed charge, they are very secure because they have a particular asset of the company, which is the security for the loan they're giving the company. But those with the floating charge, they do not have any specific assets. Their security is over a general class of assets, and their security will not apply to any particular asset until crystallization has taken place later on. And that is why if we change the nature of the business, they need to be notified so that they can pay attention and protect their security. And that is why the law says that if you decide to pass a resolution to change the nature of the business, then you should keep debenture holders secured by floating charge in the known. Okay, any question before we move on to names of companies?
Hello, sir.
Yes, go ahead.
Hello, sir.
Go ahead.
Your network, yes, your network was not, your voice wasn't too clear when you were explaining the reason why debenture holders must be informed. So I couldn't get that up. So if you can repeat.
I said that debenture holders are creditors of the company. And we have two types. We have debenture holders who have what they call the fixed charge. Fixed charge means that they have a specific asset of the company, which is the basis of their security for the loan that they're giving the company. So for them, they are very well secured because they know the particular property of the company, which is the security for the loan they're giving the company. Then we also have debenture holders secured by floating charge. The floating charge means that their security is not in respect of any particular asset, but it's over class of assets. So, and can even be the entire operation of the company. And the security will become fixed or fastened onto particular assets when crystallization has occurred. And we will learn debentures later on. So just for now, all that you need to understand is that floating charge is a security over a general class of assets. And for that matter, if the company decides to change its object or its nature of business, the law seeks to protect the interests of these general creditors so that they can coalesce or they can open their eyes regarding what the company is doing in order not to jeopardize their security, in order not to wait for the company to run its affairs in a way which will make it impossible for them to get their loan paid back or for them to get any assets of the company to sell in satisfaction of the debt which the company owes them. Yeah. So that's what I said.
Visa.
Yes, go ahead.
Many a times when a company is looking for a facility, they are sometimes asked to go and bring a board resolution to back the facility that they are looking for. Is it part of the company's, is it part of the law that the board has to prepare a resolution stating the amount that they need?
Yes, it is. Don't forget, the company is an artificial person, right? And Lord Cranworth will tell us in the case of Aberdeen Railway against the Blackhill Brothers that the company functions through the agency of flesh and blood. The flesh and blood here are the officers of the company, the directors of the company, the officers or the employees. So if the company is going to take a loan, the company must put down how much it wants to take and so on and so forth. And this will have to be done by those who are the eye, those who are the leg, who are the hand of the company. And these are the directors. Yeah, so that is quite appropriate. But we come and learn more about this when we are discussing directors, when we are discussing how the company acts and all that.
Thank you, sir.
Okay, so let's take names of the companies, and then yes, so section 21, names of companies. The reader is not there.
Section 21, names of companies. The last word of the name of a private company limited by shares shall be limited company, or the abbreviation LTD. B, public company limited by shares shall be public limited company, or the abbreviation PLC. C, company limited by guarantee shall be limited by guarantee, or the abbreviation LBG. And D, private company limited unlimited by shares shall be private unlimited company, or the abbreviation PRUC. E, we have the public company unlimited by shares shall be public unlimited company, or the abbreviation PUC. Two,
Good.
a company shall.
Yeah, so just few words of commentary before we move on. If you studied company law under the old law, like I did, that is the repealed at 179, you notice that we did not have most of these things we are seeing under section 21.1 regarding the suffixes, that is the ending of the name of the company. All that we had was the LTD. If the company is limited by shares, it will have the LTD. And you didn't really need to indicate whether it's a private or public. But that was quite confusing. So the lawmakers, in their wisdom, in the new legislation, have brought some refinement and said that, okay, if you're company limited by shares, it's a private company, just have limited simpliciter, or the abbreviation LTD. If it's company limited by shares, it's a public company, you must have the PLC. So now, as soon as you see a company with the suffix PLC, it will tell you that it is a public company and also a company limited by shares. If you see LTD simpliciter, it will tell you that it is a private company limited by shares. And of course, for guarantee, now if you look at, before we had the 2019 legislation, company limited by guarantee, we didn't have any ending. I remember I used to have a human rights company by guarantee. It was called the Center for Human Rights and Advanced Legal Research. And I used to operate in Abu Abu. There's a place called Kotoko Cinema. This was in the 2005, 2000, yeah. And for example, if we take it, Center for Human Rights and Advanced Legal Research, nothing tells us that it is a public limited, nothing tells us it's a company limited by guarantee. You have to go and look at the documents and all that. But now, the lawmaker has stated that you should indicate if it is limited by guarantee, you have the LBG. So as soon as you see LBG at the end of the name, that should tell you, as a student of company law, that there is a company limited by what? By guarantee. And the same thing applies to the private unlimited company and public unlimited company. But we should remember that if you apply to register a name for a company, your application may not be granted, especially where, in the opinion of the registrar, as section 21 to indicate, the name you are seeking to register is misleading or undesirable. So when we say it's misleading, it may well be that you have a registered constitution and you have made a statement regarding what you are going to do as a company. And if you look at the name which you are putting on the company, it does not bear any relationship with, let's say, that the statement of the objects or the nature of business which the company is going to indulge in. So therefore, the name you have is misleading, and the registrar may say no to that name, so change it. Or it may well be that the name that you have adopted, for example, is undesirable. Undesirable in many ways. Undesirable in the sense that probably it is profane, or probably it's doesn't bode well for public safety and things like that, in which case that will not be permitted, or is even insulting. So the registrar has the power to do that. And again, where the name that you propose was a name which was used by a company which have been dissolved 5 years, right, before you apply to have the name of your company registered, then that name will also not be permitted. Well, the reason being that we want the public to, don't forget that name goes with goodwill, name goes with reputation, okay? So if a company has been dissolved and reasonable period of time, in which case reasonable period will be 5 years and above, if that period does not elapse and you are allowed to use that name, in the mind of the public, they will think that it's the same company. And that is why the law allows some cooling off period that with respect to companies that have been dissolved, you must wait 5 years or more before you can use that name again. It is also permissible under section 21(4) for a company to change its name. But where the company is going to change its name, it must pass a special resolution. As I indicated to you, a special resolution means that the company, in sending a notice to convene the meeting, must indicate in the notice convening the meeting that there'll be a resolution to change the name. And during the meeting, the resolution to change the name must actually be approved by 75% of those present at the meeting. So that is a special resolution, but that is not enough. Once the special resolution has been passed to change the name of the company, you must present it to the registrar of companies for the registrar to grant a written approval before the change of name process will be completed. So let us keep that in mind. Of course, it is also permissible for the registrar on her own, that is so motu, to say that looking at the name which your company was registered with, the name is undesirable, the name is misleading, and for that matter, change it. When it is so ordered, the company has 6 weeks within which to make the change. Otherwise, consequences will be triggered. So if you look at the section 21, 5, 6, 7, 8, and 9, right up to 10, it tells us about the consequences which may follow should you ignore the directive by the registrar of companies that it should change your name, or when it has gone to court. Of course, when the registrar has ordered that you should change your name and you disagree, you can go to court and appeal the decision of the registrar of companies. But when all is done, the registrar will have to publish the new name in the company's bulletin. So the company's bulletin is a special type of gazette used for only company affairs. So when information is published there, it is considered as having been communicated to the whole society. That will complete the change of the name of the company as it were. And that is why 2113 says that a certificate or an advertisement in the company's bulletin under this section is conclusive evidence of the change to which the change of name relates. So let us keep that in mind. But another point to note is that where the company has, for example, undergone change of name, it will not affect the rights and liabilities of the company. In other words, if the company had, for example, a pending litigation before court, and the litigation is in its old name, the fact that the company has adopted a new name is not going to end the case. So that is what section 14 is telling us. Now, if you look at section 21.1, it is introducing a new regime as far as the surfaces, that is the endings of the names of the companies are concerned. The LTD, PLC, LJB, PURC, and so on. Now, so to actually ensure that the new regime is fully implemented in the country, if you look at section 21.15, there is what they call a transitional era, which is granted. So 21.15 says that a company limited by shares existing at the commencement of this act, and this act came into force 2019, has 6 months within which to comply with paragraphs B and C of 1. So if you were a company already incorporated before the Companies Act 2019 Act 992 came into force, and if your company was company limited by shares, then section 21.15 is saying that within 6 months of the coming into force of the new legislation at 992, you are supposed to pass a resolution to change the name of the company. If it's a private company, we're going to add LTD, and then if it is a public company limited by shares, we're going to add PLC. Yeah, so that is the transitional phase permitted by section 21.15. Now, the other point to note is that the law also recognizes the possibility of reserving a name. And what do you mean by reservation of a name as permitted by section 22? Reservation of name simply means that supposing you want to register a company, right? And registering and incorporating a company is not a one-day thing. A lot of things may have to go into it. And maybe there's a particular name which you think is very appropriate for the company that you are registering. But since no one has monopoly of ideas, names, and all that, what you have thought of as registering, other people might have also contemplated that name. So just before you can even go and register, you go and you are told that the name is taken, so please take another name. So section 22 makes it possible for you to apply for a name you intend to register to be reserved, right? So you get a form from the Registrar of Companies, and then you apply to have a name reserved. You can reserve a name for a maximum of 2 months. And then when the 2 months have elapsed, you have it renewed for another 2 months. So altogether, a name can be reserved for probably 4 months. So that within that period, nobody can register that name. So let us keep that in mind. Any question on the name of company before we move on to constitution of company? Yeah, Francis Pepra. Francis, let's hear you.
Hello, sir.
Yes.
Yes, with regards to section 21 of the new act.
Okay.
Yes, if you've instituted an action against a company, let's say GCB, Ghana Commercial Bank, and per the coming into force of this act, that Ghana Commercial Bank has now been changed to GCB PLC. Must you change the title of the action, or you can still continue with your action and therefore it will suffice?
Yeah, you can continue dashing and it will suffice. And I have a practical example too. If you take HFC, right, who has now become Republic Bank, there was a case instituted on behalf of a client against HFC. And then in the course of time, they underwent change to become Republic Bank. So they brought a motion for the name of the, the defendant to be changed to reflect the new name. And we did not oppose it, and then the court granted it. Because as we have indicated, if you look at section 21, it is quite clear that the mere fact that you have, look at 14, right, 21:14, a change of name by a company shall not affect the rights or obligation of the company or render defective legal proceedings by or against the company. And the legal proceedings that might have been continued or commenced against the company under the former name may continue or commence against the company under the new name. So the mere fact that you have a change in name does not affect. You can apply to have the new name to be substituted. But if it's not done, it still does not affect. It's the same thing.
Very well, sir.
Okay. Constitution of the company. We'll end here, and then I think we'll continue with that probably tomorrow. So have a good night.